Okay, hello all and welcome to the second session of the Cloud Security Alliance Innovation Summit inside Cyber Week. First session was about innovation in cloud computing, and we talked to a couple of founders from the promising startups about how they plan to innovate the cloud security challenges, how they plan to overcome them. And this session, I think it's like the opposite, 180 degrees from the last one. We are not going to talk about technology. We are going to talk about legal stuff. We're going to talk about how the world of technology and legal is going to coexist. And we're going to talk about, we're going to talk with our guest about the legal and regulation and legislation of privacy laws that is blooming around the world. And is it good or is it bad to innovation, and how we can, I don't know, I have my opinion. I'm trying not to say it before time. With me, of course, is Amit Ashkenazi, legal advisor, National Cyber Directorate. Hi, Amit. Pleasure to have you. Thank you for joining us. Dalit Ben Israel, head of IT and data protection practices at Naschitz and Amir. And co.
Hi.
Hi, Dalit. Pleasure to have you. And of course, Max Sxhrems, privacy and civil rights activist. And I don't think you need to be introduced, but you recently, I think 2 years ago, you started working under NOYB. I am saying this right, which is basically means none of your business. And I really love to hear what are your plans next. I mean, I guess our audience heard about Sxhrems 1 and now Sxhrems 2. I would really love to hear what's next. I'm going to start, since we don't have a lot of time. Basically, I'm going to speak from entrepreneur point of view, not as a lawyer, okay? And as entrepreneur in the last couple of years, there's been a great development in cloud computing. I mean, cloud computing became amazing. I can launch workloads across the ocean from my tablet, no effort at all. But where do I get the problems? Where do I get the challenges? Legal and privacy laws. I mean, basically challenges all the time for entrepreneurs. Now we are spending more time on the legal stuff than the technology stuff. Bottom line today, let's say I'm developing this amazing, I don't know, magical solution. I'm solving the COVID-19 problem. I will have to build 2 data centers, one for the EU and one for the United States. I'm not speaking about India, China, and Russia and other countries. I mean, I have to double my effort, double my expenses. And it's basically, I think, from my point of view as an entrepreneur, it's blocking innovation. Instead of bringing bringing medical innovation, I'm tangled in producing papers and writing and getting legal opinions and giving my money to lawyers. Not that it's a bad thing, but it's not promoting my business. Excuse me, all the lawyers in the audience. So my first question to you, Max, is that how are we going to solve this? I mean, aren't you blocking innovation in this way? And before you're going to answer that, give us an update on what's next on your plans after Sxhrems 2. I mean, where this is going, what is the next step?
Yeah, thanks a lot. So there was a lot already to unpack. So basically, we have this new case called Sxhrems 2. All of these cases are basically about international data transfer. So the problem is each country in the world is now passing its own laws about what you should do with data. And they are fundamentally oftentimes conflicting with each other. So one country says you have to provide all the data to our security services. The other country says you have to provide proper privacy. And as a company, you may simply get in conflict with one of these laws. So I think already from the premises of the question, there are usually conflicting laws, and it's not necessarily the privacy laws that are the cause of the problem. You may just flip it around and say the security laws of another country are the problem here. And I think in a way, the problem on a meta level is conflict of laws. We simply have 200 countries in the world that all now claim jurisdiction over data. And as a company, you're somehow in between all of them. And I think that is a fundamental problem we'll have to deal with in not only privacy, but let's say, hate speech or tons of these issues. I remember Facebook has announced recently now that they will now finally take off Holocaust denial speech. Now, on the US perspective, this was freedom of speech. And there was a couple of years ago, an internal document by Facebook saying, we'll only take it down in Austria, Germany, France, and Israel, I think, because that's the only countries that ever enforced a law against us. And for all the rest of the world, we know that these laws exist, but we ignore it. So there is a lot of these conflict of law situations. And I think to just limit it to privacy is even making the problem smaller as it really is, because we'll have the exact conflict of law problem in tons of other sectors as well, and tons of other issues as well. And that gets us a bit to the question of how to solve it. I think the only way that we solve it is that we have some kind of common ground of a minimum level of protection that is independent of citizenship, independent of where you are based. And that could then allow to have a free flow of data. And that's a kind of what the GDPR tried within the EU. The whole reason why we have privacy laws in the EU was that each member state in the EU had its own laws. And then you had the same problem within the EU to not be able to transfer data. So they tried to kind of overcome the problem within the EU and basically through so-called adequacy agreements, sign up as many countries as possible onto that system. And that's a bit, at least on the privacy side, what we try right now. But quite honestly, the more we connect everything globally and the more the government will get, or politics or democracy will get involved into the digital sphere, the more these conflict situations we'll have. And that goes far beyond privacy and is a fundamental problem. And a hopeful note at the end on this intro is, I think at least among like the Western democracies, we should be able to have a common understanding of baseline protections, to say there's a baseline understanding of freedom of speech, there's a baseline understanding of privacy, for example. But to give you the extreme example, if it's national security, we don't even have that baseline understanding within the EU because that's exempt from EU law. So if I'm as an Austrian citizen surveilled by the German state, there is no place I can go within Germany to get my rights because as an Austrian, I don't have any rights in Germany. So, and in a globalized internet, that's absurd. Like that's a situation that we need to debate in a way and we'll have to overcome in one way or the other, just probably not anytime soon and not with like a quick fix in any way.
I remember from our conversation a couple of years ago that you specifically emphasized how different privacy views are different from United States and Germany. You gave examples of sexual tendencies and salaries that they looked upon differently in different countries. So do you really think that giving that utopia that you mentioned, that we'll have one harmonized law, at least in the Western world, do you think it's possible, given the fact that privacy is...
No, we're not going to have a harmonized law, but we may have situations where we are close enough to accept each other's law as adequate. That's what at least EU law calls it. So it doesn't say it's the same, but it's somehow more or less okay for us. And in law, in international law, we're used to that a lot. Like usually, criminal systems are very different in each country, but we still extradite people to each other and cooperate in criminal cases, even though the law may not be the same, but it's more or less on a Western standard. And I think that is especially a problem in national security situations because that sector has traditionally been a my state versus the other state situation, but got into a territory which is more kind of espionage on average people as well, in the sense of the number of data that's, for example, forwarded by Facebook or Google or any of them to the NSA is really vast. It's not your individual spy from Russia that you now try to find. It's really mass surveillance in a way because of the terrorism situation. But the shift has changed from like really going in against another state to going in against individuals in general. And so while the interoperability has become much higher, there is just de facto now my data in the US, which 30 years ago, just bandwidth-wide wouldn't make any sense. It would be stored here. And so we now have all this flow of data. At the same time, we're still thinking in a very nationalistic way about national security. And that gets into a certain tension there. Again, I think it's not going to be, we're not going to have a common understanding of freedom of speech, for example, between Europe and the US, because there is a very different view of how far this goes. But a general acceptance of somehow being on the same line on these things could be possible. And that's unfortunately, the underlying need to then have free data flows, because you mentioned, outsourcing. If you outsource something to a country that doesn't have any labor standards and that doesn't have any, environmental standards and so on, you're basically undermining your own system to a certain extent. And exactly that's the problem that we have with fundamental rights. It's, for example, we can't extradite people to the US because they have the death penalty. And if that's the risk, then you can simply not send someone there, because you may walk around and say, oh, we don't have a death penalty in Europe. They're like the biggest fundamental rights people the world has ever seen. And 2 seconds later, you extradite someone to, I don't know, Iran or whatever. and that would undermine the basis of your whole law. And exactly that problem happens a lot with international data transfers. And it's a huge issue.
Okay, I'm moving on because
more cans of worms here, but I guess I did.
I'm going to switch to Amit and ask him, you are the cyber regulator, the cyber directorate. I mean, how do you plan to solve this? I mean, you basically, your job is producing more regulation, yeah? The title, at least, as it's supposed to be. How do you help us promoting innovation?
I think that what the ECJ did this second time around is actually sent all of the civil servants, not just in the cyber directorate, but mainly DPAs and others negotiating from both sides of the Atlantic, and of course doing this job, to reconsider whatever they have thought. Because after Sxhrems' first victory, we thought that the world will adjust itself, and the civil servants, the executive authorities, if you like, are in charge of building the bridges, because constitutional courts show the values that we should respect, but they are not built for the day-to-day manual labor of international data transfers and mitigation of risks, etc. And this second time around, we've got a verdict which is says you haven't been studying well enough, you should do your homework again, this is not sufficient, and we want you to think what you're doing. And actually, when we look in this panel, we see the civil rights activists, which rightly so, activates for privacy. We see the entrepreneur, which wants to develop and innovate and has no quarrel with Mr. Sxhrems' data. And we have a private sector lawyer that needs to give advice. And you ask yourself, who is in charge to build the bridges? And I think it's up to us civil servants to look at how we make interoperability from a slogan which we some years ago actually believed in. I mean, if we recall the OECD privacy principles, they were intended to build bridges. I recall Mr. Peter Hastings, the famous European data protection supervisor's word about European data protection regulation of international transfers as being pragmatic, meaning recognizing other cultures have different values and different structures. But again, as the world becomes more difficult in a lot of senses, both in the economic sense and in the cultural sense, and also in the legal sense, these jurisdictional issues become a lot more conflicted. And I guess we should go about building these bridges with our colleagues overseas. Specifically for us as the Cyber Directorate, we actually think that some of the services supplied from abroad, this may be a bit dramatic, may be safer than some of the services that our own suppliers supply in Israel for most of the stuff. Mm-hmm. So we think that international transfers can be cybersecurity net positive. And so we have a role there to enable startups to utilize cloud services in certain risk scenarios and give them some clearance in that area.
This is an interesting declaration. Not coming from cyber.
I think that we've been saying this in different scenarios. I mean, we don't actually say, no, you have to go to the cloud and please transfer your data abroad. But we think that in some situations, given the risk scenario, this can be a viable option which gives more safety in these risk scenarios. So, and of course, these types of granular discussions are not built for constitutional courts. And the Constitutional Court should do the oversight and see that we're on track. And I hope that when Sxhrems 3 comes along, either the... I hope that we will have done a better job, and of course, in creating this more clarity, and maybe the Constitutional Court itself will will give respect to all of the sweat of the civil servants, which I think about in Brussels, very smart privacy lawyers that actually got this verdict, which says basically go back to the drawing board.
Yeah, definitely. That's a big mayhem over there. Max will probably can tell us the insight of that. I'm moving to Dalit. I mean, you present your customers are startups. You present many startups. I mean, they're coming over to you and saying, "Help us with this jungle of laws and regulation. We want to sell in Brazil. We want to sell in the United States. We want to sell in Europe. Help us in sorting out all of this." I mean, how can you mitigate the risk, and how can you help them perform compliance that is efficient and affordable for young companies? Again, from my point of view, the large companies can afford this. I mean, they can build data centers all over the world. The problem is always with the smaller companies. This is the biggest barriers.
So I think that basically for a startup, let's say a .com company that's just been starting to operate, you cannot be legally compliant in each and every jurisdiction that there can be one single user accessing your website. And I don't think there is such an expectation by any authorities anywhere. But what you need to do is you need to be compliant with the baseline. And as Max said before, there is a more evolving culture of, let's say, in the last 2-3 years, of sort of what I would call a baseline of privacy laws around the world. And by the way, also in the sense of information security standards. And what I always tell my clients is that if you start with, let's say, an ISO 27001 certification, then you know you have some kind of common ground that would be acceptable in many jurisdictions for your security. It would also comply, by the way, that the Israeli Data Protection Authority has recognized that if you have ISO certification, you are exempt from many of the specific requirements of our security regulations, and you only have to comply with a delta of them. So this is one way to tackle it from the information security aspect. The other one is to adopt basic principles in your jurisdiction and maybe map the 1, 2, 3 jurisdictions where you are mostly active and try to perform compliance there. Assuming it would be, let's say, 80%, 90% compliance, depending on the jurisdiction in which you operate. You also need to take into account that today, not all privacy laws and data protection laws around the globe have extraterritorial applicabilities such as GDPR. So if I'm an Israeli startup, I need to be compliant with Israeli law, assuming I have also business and clients in Israel. I would most probably need EU compliance because most companies that I would sell to would either be in the EU or would have business or data subjects in the EU where they would seek my compliance. And then the US is a totally different angle because US has no federal privacy law. There are different states that have laws relating to privacy, mostly in relation to breach notification, and we are seeing more and more bills to adopt specific privacy laws in specific states, and that's such as the California Consumer Privacy Act that is already in effect. So currently, when startups need US compliance, they usually do CCPA compliance, and they wait to see what is going to happen in other states, which start to follow the CCPA or maybe have smaller CCPAs like in Nevada. That would be the advice to give to startups. And in that respect, most of the startups operate on cloud environments. So the recommendation there, and that I am connecting to what Amit said, would be to urge them to look at larger cloud vendors, ones that have published their security controls, that publish yearly or periodic audits that they have undergone by external auditors, and to get more certainty about the security controls, the practices of those vendors. Because if you contract with a very small local vendor, you might not get the same compliance that you will get from a larger vendor. Of course, it depends on the risk, the type of data, but that would be another sound advice, I think, for a startup.
Okay, so basically, just trying to summarize this, first of all, you're saying that from security point of view, we do have some kind of baseline to work with, like ISO 271, SOC 2, and stuff like this. So I imagine that also in privacy, I'm trying to take out what you said. Most of the privacy laws around the world are pretty similar, right? We have like a very small fraction of data different between them. I mean,
no, I think there are the high-end privacy laws like GDPR. Israeli law is marching in the same path. CCPA is in the same path. The new law in Brazil is in the same group of privacy protection laws. But in many other jurisdictions, the laws are not that evolved yet. And for instance, in the US, breach notification in the US has been there long before it was introduced into GDPR. But on the other hand, I was assisting a client that needed to do some business in Louisiana, and I was checking, and there are no privacy laws in Louisiana. You can do whatever you want. You don't need a privacy policy. You don't need to tell a user that you're taking their data, and you don't need to tell them what you're doing with the data. It seems like an absurd nowadays. I mean, who doesn't need to tell the end users what they're doing with their data, where they're taking it, and who else they're sharing it with? But that's the situation in many states in the US. And of course, in many other parts of the world.
Yeah, the US are probably still waiting for their GDPR to harmonize stuff. But that brings me to another question, and Max touched it a little bit. I mean, GDPR was meant to harmonize the different laws inside of every EU country. And I still remember from my entrepreneur days when we have to work on every country in Europe, which was very complicated stuff. So it's definitely harmonized, but it also put in a very high standard. So in the end, a startup in the EU, it was much easier for him to now work on one law, but the law become much more complicated. So a startup in Louisiana, for instance, has a much easier life over a startup in Vienna or in Berlin or in Paris. And this goes back to you, Max. I mean, is GDPR should be that high? Or and like Dalit said, CCPA, and everybody will push it. This is the new barrier, and this is the new common denominator. Or do you think that we are going to reduce GDPR a little bit in order to avoid the complexities it is producing?
So I think to start off with this, I have to get a bit political because the interesting thing when the GDPR was negotiated, the whole privacy bubble and the kind of reasonable people in the room had very clear ideas how the law should be, and especially for SMEs to say, let's get a class A, class B, class C provider, where we say, small companies only class C, that has to only comply with the core of it. Then there's like middle ground, and then there's like Facebook and Google that get like the full load of it. And interestingly, the industry has pushed back against that idea because the people that have the most lobbying power, even in Brussels, is the big companies. So they wanted to have one size fits all law because they were like, oh, let's have everybody in class B instead of having us in class A and someone else in class C. And that is what they then called a risk-based approach. And there was tons of wording around it. But the bottom line is they tried to get a middle ground law for everybody, which is killing small business and is way too little compliance for the really big guys, to be honest. And that is combined with a lot of wacky parts of the law. So there were, I think I'm one of the only people that read the 3,600 amendments to the GDPR that were put forward in the European Parliament. But for most of the things where there's now legal uncertainty or people say, it's very complicated to read, there was a proper amendment to fix it. But it was pushed back by the industry. The industry rather wanted to have a wacky law where they felt like, okay, we can probably argue our way around that wording. And now, especially the SMEs are complaining that no one in the world understands what this law means. So it's really interesting because from a privacy professional and a privacy advocate perspective, we are oftentimes, I would say 95% aligned with the interests of SMEs, because SMEs usually don't want to do shitty stuff with data. They just want to be done with compliance and move on with their business. And the GDPR is, I think, politically on what it does and what the aims are makes a lot of sense. But it's technically a very bad law. The way it's written, the way it's drafted is technically not a good job. And the interesting thing is that did not come out of politics, that did not come out of the commission, that did not come out of the privacy people, that came out of the industry itself. And I think that is a lesson to learn for any other GDPR-like law in the world, how not to do it, because we really have to kind of see that there are differences in the industry and also have to change the law accordingly. Any other law that I'm aware of, if you bike, you have other rules than if you run a car on the street. It's just a different thing. And that's also true for privacy in many respects, and the GDPR does not include that. Two things on what was previously said. I think Convention 108 is interesting on a global level because a lot of these structures come out of Convention 108. I would
Can you elaborate what it is, Convention 108?
Convention 108 is by the Council of Europe, so beyond the European Union, a convention that should get baseline rules of privacy. It's in the GDPR, basically Article 5 and 6. There's a load more in the GDPR, but these core rules that you need a legal basis, that you have to delete data that you don't need anymore, all that kind of stuff is in Convention 108, and it was upgraded recently. And the Council of Europe tries to get as many countries to at least follow that baseline system. A problem is really, as you mentioned, the US, because there are ballot initiatives, state initiatives on only one type of processing, which gets really fragmented and really complicated to navigate. And they do not follow Convention 108 in many ways. Even the California Act is not really there. And one last thing on the local vendors, I think there is a lot of, like from a security perspective, a lot to say for like the big vendors. On the compliance aspect that we see in Europe right now is the big global vendors simply also fall under US surveillance laws. And that is exactly where the incompliance then comes in on the data transfer side. So I'm oftentimes advocating for mid-size, larger, I don't know, there are big German, for example, hosting providers that can also do cloud computing as the big ones do as well. But they do not fall under these US surveillance laws. So there may be a middle ground that for certain situations may be the better option than the very large guys. If you look at, for example, what Microsoft and Google does now on US surveillance, they blatantly say it doesn't exist. Like they put out blog posts saying we're fully compliant with the GDPR. It's all good, just carry on. I'm wondering for the first lawyer that looks into damages claims against these companies, because if I invest millions of euros into a Google Cloud solution just to find out in the end that it's actually illegal top to bottom, then I would probably want to get my money back as a business. And I think that's going to be an interesting debate down the road. But they're still in total denial. And I think that's also a bit of what we could learn from the Safe Harbor, now Privacy Shield. I don't like to call it Schrems 1 or 2, but from these judgments is that we have a fundamentally incompliant industry. It grew since the 90s with the understanding that these laws are not going to be enforced. So it was just, they did something else that was outside of the legal scope. And now this industry has to be squeezed back into the GDPR. And that's a very harmful and damaging and problematic process in many ways. And I think that is what probably the Court of Justice has sent as a meta message, is that they will not step down. They will not ignore it or look the other way. They will make the industry comply even if the DPAs won't do that. And I think that is a very interesting message, that the GDPR on a legislative side was pushed. There was a lot of push for privacy. We have it from the courts now. What's still missing in the EU is the data protection regulators in many countries. That's very fragmented. Some of them are very proactive, others are not. But for example, the main regulator is still Ireland because of tax avoidance. Most of these international companies are in Ireland, and they still don't decide about, I think, 99% of the complaints that they get. So we're in a situation where you have a law on paper in Europe, but a lot of the industry is still not complying, and a lot of the enforcement has not happened yet. And especially if you start new projects, I would put it on a solid foundation instead of putting it somewhere that just for historic reasons is oftentimes not really built to be compliant. And if we're talking about project that should last, 5 years, 10 years, something like that.
Okay. Amit, I'm taking this to you. I mean, where do you see your job in this? I mean, do you see a way that we can harmonize this globally? Can we create one law? I mean, in Israel, we always rely on other people's standards because we're too small to, in most cases, to create our own standards. For us, it's easy. Do you see a way to harmonize EU and United States, for instance?
So basically, this, I think, ties in several of the themes that Max raised and also we have raised. I think there is one hard topic, and this is a hard topic. This is the issue of national security and how states think they need to defend their essential interests. And this becomes trickier in a world which people move around, and you don't know at first if they're friendly or not friendly, and they may have even EU citizenship as they enter your territory. So this is a hard topic, and it needs to be mitigated. I think that we are seeing some work done there in what is known as the Microsoft Ireland case and the US Cloud Act, because you see pushback from the industry when the US government comes and asks for data about citizens. So I think this would be, in my view, a complementary or the anti, if you like, Sxhrems 1 case, because it deals with how US companies are pushing back. So national security is still going to be hard. And thing is, when the dust settles, you'll find that as Max really candidly said, maybe some of the national security laws in Germany or in Austria are not as transparent or with the same checks and balances as you would have in the US. And I'm saying this as a hypothesis, I haven't checked them. I think, but though, that where we're
100% for sure. Especially it's going to be very interesting after Brexit, for example.
Yeah, but this is our next question, so don't spoil it.
but anyhow, I think that the world is changing this year, and it goes to all of these issues of these internet companies that have been sort of outside the legislative process in many, many ways. They have had these anti-legislative clauses, and we're seeing a huge pushback by the US Congress, by regulators. We're seeing federal privacy legislation. I think that this type of legislation in the US and the criticisms which we're starting to hear, Max was really clear about these criticisms of the deficiencies of, I may say, over-regulation. We're not in conflict about the right of privacy, nor in Israel. It's a constitutional right. Our constitutional court has many times shown the government what it thinks about its activities in this area, but it's the mechanism that may have what we call false positives. It's not efficient. And I think that both this sort of reaction in the EU and what is going on in the national level in the US may bring these continents further in the commercial sphere. And this goes to my last comment. I think that in the national security realm, the issue is a lot trickier, and I'm wondering whether what we heard from Max is actually that his quarrel is not really with the US government, but rather with several major US companies that have a lot of data and show disrespect for EU law inside the EU, which is actually a completely different story. And maybe, I mean, I'm just saying this as a reflection on what I've heard here. And then in our system, this is something that is going now on in the Israeli legal system, we're starting to see civil liability claims against these companies. And we see our courts now not shying away from the jurisdictional issue. They're saying, well, if you offered a service to an Israeli customer in Hebrew, we will go after you. So this is just as a side note. Mm-hmm. And this also creates more harmonization, because these companies need to respect these laws all over, and they have an incentive to have a level playing field.
Okay.
Dalit, optimistic somehow.
Mm-hmm. I'm switching on because again, always pressed with time. Dalit, where do you think this will end? I mean, the need to balance the requirement for privacy and innovate. We comment?
I think that in all spheres of law, usually the law comes after the technology. The technology and innovation come first, and then the laws try to adapt. So I think the consequence from that is that laws need to be more flexible and adaptive in their nature to the climate and the innovation, because otherwise innovation will be totally blocked. It's the same in IP-related laws, and it's the same in privacy. Just as an example, we were talking about the transfer of data, the cross-border transfer of data, under the Israeli, very ancient, I would say, regulations of cross-border data transfer. One of the restrictions is that data cannot be further transferred. Now, this is an absurd today in the cloud era, because you send data to the cloud. You're allowed to do that. Let's say the cloud, the data center is located in the EU, and you're fine from cross-border data transfer restrictions, but then you're not allowed to transfer it more. And that's what these very ancient regulations that have been on the table for change during a long time, say. So the community or the people engaged with this find creative solutions, like saying in the contract that the data is not really transferred by the cloud provider to the subprocessor. It's sort of bounced back to the data controller, and then the data controller actually through the cloud provider, it is the party that is transferring the data to that subprocessor. And there are all kinds of legal ways to tackle this. But this is just an example to show that the laws are very, very far behind technology. And in that sense, referring to Max's criticism on the GDPR being a very, I think, non-descriptive law and very principle-based law and not going down to specifics of technology, maybe in some circumstances it's preferable because it enables it to be still relevant, let's say, in I don't know, in a year's time, when encryption is no longer deemed as a very state-of-the-art technology and there's something else that has been invented. As opposed, by the way, to laws in other jurisdictions like Israel, where the laws are very descriptive and they tell you exactly what to do. You need to use multi-factor authentication when you access through public network. I mean, multi-factor authentication may not be enough. In I don't know, in a few months' time or in a year's time, technology will invent other things. So that's basically it. And just one more comment on this is that I think another way to tackle this is to publish centralized guidelines in certain areas, enabling companies from more and more jurisdictions or from more and more countries to work based on the same principles. And this will also promote innovation and preserve privacy on the other hand, like the EU that published central guidelines for contract tracing apps. And there were guidelines all across the EU telling all countries, please try and abide by them. And there's certain guidelines to that effect regarding AI being worked on in Europe. So this is also another angle to enable the innovation and the laws to evolve at the same time.
Okay, so we have our last 8 minutes. I want to go to our last topic. And again, this is going back to Max, exactly what I was mentioning before. So now the data is protected from the United States. Well done, Max. The NSA is far away from our Facebook data. What about other governments in the EU? This is a claim I constantly hear about as an opposition to Sxhrems 2. Our data is not safe because there are other countries in the EU with similar laws. Yeah. How do you respond to that?
Two things. First of all, just quickly on what Dalit said on the flexibility. I think that's exactly one of the benefits of the GDPR that you described, that it has this meta principle-based thing, because most of the GDPR is literally from the 80s, like not much has changed. And that shows how it was written in a way that it's flexible enough to cope with new technologies. What I meant more is to have different classes, for example, and say, the privacy impact assessment 21 does not have to be done if you're an SME or so. And we also can have that on a flexible level in the sense of, I don't know, when e-scooters came around, we didn't have a new law in Austria on e-scooters, but there was simply a class of how many megawatts your machine on two wheels has that then says you fall into the class of being a motorbike or a bike or something else. And if you have flexible things like that built into the law that give you these, somehow clearer guidelines, but in classes that could probably be helpful. Other topic, back to the other companies, to the other countries. So it's a mixed argument. So first of all, it's totally true that certain EU countries have similar surveillance laws. Now, that's not the whole EU. From the US, it's basically said the EU does that too. It's to a large extent the UK that is probably the worst. France is pretty strong as well. Germany, in a large extent, in cooperation with the US. Sweden, interestingly, by being a smaller country, however, has larger capacities in that respect. But then it's about it. Like the serious surveillance, like Austria doesn't have a secret service. We have a police force that's in charge of terrorism, that's it, but they have the same rights as any police officer on the street. So to say, the whole US does the whole EU does the same thing as the US government is just ridiculous. Also, just size-wise, a country of 8 million people is not ever going to have the powers of the NSA. So I think that there is truth to it in certain extents, but that's not 100% the same. What is different to the US is that no matter where you are in the EU, there's at least a baseline protection of the European Convention of Human Rights, which also applies to national security. And there is nothing like that in the US. If you are not a US citizen or permanent resident, you're simply out of the protective sphere of the US Constitution. There is no general law that gives you any privacy right whatsoever. And that's exactly how US surveillance laws work. They work by sorting Americans from non-Americans, and Americans go into the trove of being protected, and the rest you can do whatever you want to do. And there's a lot of talk about guidelines and blah, blah, blah. But if you really go through these laws line by line by line, it's a bit like going through a computer code. You see that none of these filters ever hit you. and so it's nice to say we have 20 filters built in, but if you know that by definition, none of these filters would ever protect you, then the whole point is kind of lost, you know? And that is a fundamental difference that even though the Convention of Human Rights and the Strasbourg case law is very permissive on mass surveillance, extremely permissive, there's at least somewhat of a baseline protection. So it's basically a bit like, you know, a computer code where all the filters that they praise that they have are literally by definition not applicable to you. So after all, you have a law but no protection. That is a fundamental problem in the US because the US simply just talks about citizenship and non-citizenship, and non-citizens are simply not protected, especially not under the Fourth Amendment. So you can literally do whatever you want to do. And that's also how the law works. It simply sorts out US citizens from non-US citizens, and non-US citizens are fair game. And that is something that is different than in, at least in the EU. But it's definitely not different than in Russia or China or many other places. On that criticism, I think what's important to mention is that de facto our data goes to the US. Like other than TikTok, I don't know anybody that really outsources data to the US and to China. And even TikTok said actually their data is stored in the US. So the argument about China and Russia is kind of cute, but it's just not who is on our market and where our data actually goes. If that changes, obviously the debate changes. But also it shows a lot that companies already today do not outsource to China or Russia, probably because exactly of these concerns. So I think a lot of this criticism is somehow has some meaning in it, but if you dive through it, it's probably not that convincing after all.
Okay, I'm gonna stop you and move to Amit because we are running out of time. Amit, so what do you think? Is it right that the US is taking all the hit? I mean, of course, all the companies are there, but they definitely, with things like Cloud Act and Patriot Act, they definitely raise the hit on them. So what do you think?
Well, I think basically the US is a superpower. It's part of the Five Eyes. It has a world leadership role, and it's a superpower. So basically, it gets a lot of attention. And as you mentioned, all of these companies, or most of them, but there's a change in the world, are US based. And so that's why they're a serious target. But I think that as the world develops, and we'll see this, we're starting to see this already, some of the companies that are world leaders in our internet lives are not Americans. So in 5-10 years, this may be different, and we will need to look at it again.
Yeah, definitely. Dalit, your opinion, and I will add one more comment. I mean, I see you represent a lot of startups. Have you, one of your customers maybe gave up on the opportunity of working in Europe because he didn't want to add double everything?
I think that if I answer your last question first, many Israeli startups start with the US market. Not only because of regulation and data protection, but it seems like also in these aspects, like an easier market to penetrate and less costs for less costly to start your business in that manner and get your install base and get your customers. Way back when all these privacy laws started emerging, I remember there was a difference in the fees that you paid for cloud storage between the US and the EU, and you would pay like 20-25% more for cloud storage in the EU because the cloud companies had to employ much more technology and much more safeguards. So that would also be a cost imposed on the startups. And sometimes when I start counseling a company, and I ask them, that's one of the first questions I ask them, because most startups work on cloud environments, some kind of cloud environment. I ask them, where did you choose to locate your data? And when they tell me somewhere which is not the EU, I would tell them, if you're also targeting the EU and Israel, you should think about moving your cloud to the EU because it would solve a lot of problems. Of course, access to data is not only where the data is located, it's only part of the picture, because if the data is accessed from a different jurisdiction, the same rules would apply. And just one final comment, because our time is up, is that the so-called Sxhrems 2 decision, it relates to the US because that was the specific, those were the specifics of the case. But it's actually a decision relevant to any cross-border data transfer of EU data to any jurisdiction that has not been declared as adequate. Mm-hmm. And pointing that out, even those jurisdictions that have been the very few which are part of this exclusive club of adequacy decisions of the EU, all these decisions have been rendered pre-GDPR and pre-cancellation of the safe harbor. So they are all under review within the EU, and based upon the reasoning of the judgment and the surveillance laws, we don't know how they will end up. There was a statement said by Helen Dixon in one of the webinars after the CJU judgment, questioning whether Israel, with its surveillance laws and the tracking of the population now for the COVID-19 pandemic, whether Israel would again pass the adequacy test. So nonetheless, this decision has effect way beyond data transfers from Europe to the US.
Yeah, okay. Thank you for that. We are going to wrap things up. I'm going to leave you with one last closing sentence. Max, do you want to say something as a final word?
Literally everything was said on this, I guess. Thanks a lot.
Okay, thank you very much for having us. Amit, last word?
I think it was a great discussion. Thank you for setting it up. I enjoyed it. And of course, hearing Max is always refreshing. Thank you.
Okay, Dalit?
After Amit's closing, I have nothing to add. I agree. Okay. Thank you for having us, and I hope the audience will benefit from this discussion.
So thank you for joining us. Thank you all for your insights. Enjoy the rest of Cyber Week, our audience, and goodbye to you all. Thank you.
Thank you.
Thank you. Bye.